In New South Wales, we don't have a right to protest. A range of legal amendments were passed in 2006, making it more difficult to arrange public gatherings. So New South Wales citizens do not have a right to publicly demonstrate, protest, form a procession, or even gather for any common purpose without authorisation by police or by a court. A person needs to seek approval from police to protest even against the actions of police. So for example, if some police officer were to bash and kill a member of your family, then you would need to apply to the Commissioner of Police to give you permission to protest against police. In fact, it is a criminal offence to knowingly join or continue in an unlawful public assembly, and this is under section 545 C of the Crimes Act here in New South Wales. The maximum penalty for that offence is 6 months imprisonment and or a fine of $550. Sections 22 to 27 of the Summary Offences Act 1988 prescribe a list of requirements for any intended public assembly. It requires a written notice to be served on the Police Commissioner. It requires that that notice be in the form prescribed by the regulations, and it must contain a range of particulars, including the date, time, and place of the proposed public assembly. If it's a procession, the time of the commencement, the proposed route, and any stopping points, the purpose of the proposed assembly, and the number of persons expected to attend the proposed assembly. That notice must be signed by a person who takes responsibility for organising and conducting the proposed public assembly, and it must contain his or her address for service. Now, an assembly will be authorised if the Police Commissioner receives the notice at least 7 days before the date of the proposed gathering and does not apply to prohibit it, or if the notice was served less than 7 days before the proposed public assembly, if an application is made to a court, which then authorises it. The Police Commissioner can object to a proposed public assembly even if it complies with all requirements, and that objection is made under section 25 of the Act. So the Commissioner makes an application to the District or the Supreme Court, and the court will then decide whether or not to allow the assembly. The court is to decide the objection as quickly as possible so as not to hold up the proposed assembly. And the court is supposed to weigh up the interests of free speech against the maintenance of public order, including the ability of police to, quote, exercise powers of arrest and prosecute for the full panoply of offences possibly applicable. And this is a decision of the Supreme Court of New South Wales. In practice, the organiser will have limited funds to get lawyers to fight for them in court, and they will be up against a police commissioner with many lawyers and virtually unlimited funds at his disposal. So there will be a huge power imbalance between the organiser and the police commissioner. If the organiser hasn't served the notice on police at least 7 days before the assembly and police haven't written back saying that it is authorised, then under section 26, the organiser can apply to the District or Supreme Court for approval. However, this may be very expensive, and again, there will be a power imbalance, and the person may need to seek out a solicitor or a barrister who will undertake the case on a pro bono basis.